Is a real estate purchase agreement the same as an offer in New Jersey? Buying a home in New Jersey can feel overwhelming, especially when an offer starts to look like a binding contract before you fully understand your rights. A real estate offer and a purchase agreement are closely connected, but they are not the same. An offer is the buyer's written proposal to purchase a home on specific terms, while a purchase agreement is the binding contract that exists after the seller signs and the 3-day attorney review period passes. In New Jersey, both documents often begin with the same standard real estate contract form prepared by an agent. That form usually includes the purchase price, deposit, closing date, and any contingencies the buyer wants included. Before the seller accepts the terms, the buyer can usually withdraw the offer without penalty. After both sides sign, the contract enters attorney review, which gives each party an opportunity to have a lawyer examine the agreement before it becomes fully binding. The attorney review period lasts 3 business days, starting on the first business day after the fully signed contract is delivered to both parties. Weekends and legal holidays do not count toward those 3 business days. During that review period, either party may cancel the contract for any reason without penalty and without losing the deposit. Once attorney review ends without cancellation, the purchase agreement becomes binding, and the contract terms control what happens next. At that point, a buyer can usually walk away only if a contingency fails or another contract right applies. A strong purchase agreement should identify the parties, describe the property, state the price and deposit, set the closing date, and clearly spell out every contingency the buyer is relying on. Important contingencies can include financing, home inspection, appraisal, sale of an existing home, title, and allocation of closing costs. These provisions matter because missing or vague language can create disputes and shift leverage at closing. A real estate lawyer can help make sure those protections are written clearly enough to work if a problem comes up. If the property appraises below the contract price and there is an appraisal contingency, the buyer may be able to renegotiate, pay the difference, challenge the appraisal, or walk away with the deposit protected. Waiving that contingency removes an important layer of protection and can increase the buyer's financial risk. The period between signing and closing usually includes inspections, the mortgage process, the appraisal, title work, and sometimes a survey. Each contingency has its own deadline, and missing a deadline can waive the protection tied to it. Closings commonly happen 30 to 60 days after the contract becomes binding, although financing and title issues can affect timing. The page also warns about tie-in arrangements, which can raise legal concerns when a seller or agent tries to force a buyer to purchase an additional service as a condition of the sale. That can include pressure to use a specific title company or another related service the buyer did not freely choose. Having a lawyer review the contract early can help spot hidden conditions, unclear terms, and risks that may not be obvious at first glance. An attorney can also negotiate addenda during review and protect a buyer or seller before the agreement becomes fully binding. If you are unsure whether the papers in front of you are just an offer or already a purchase agreement, speaking with a lawyer or attorney sooner rather than later can help you avoid costly mistakes. If this process feels stressful or uncertain, the Matus Law Group is a law firm that understands how much is at stake for you and your family. If you need guidance and peace of mind, the Matus Law Group law firm is located at 125 Half Mile Road No. 201A, Red Bank, New Jersey, 07701, United States, and you can call 732-785-4453 to speak with someone who can help.